This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa
All rise. The Honorable Chief Justice and Justices of the Supreme Court. The Honorable Supreme Court of the State of North Dakota is now in session.
Good afternoon. Please be seated. We're here at the time set for oral argument in file number 2025-0392, State of North Dakota versus Benito Fox. Sitting this afternoon are Justices Jared Tufte, John Jensen, Douglas Barr, Mark Fries, and I am Lisa Fair McEvers. Arguing this afternoon for the appellant is Mr. Ettinger, and for the state, Mr. Samuelson. Mr. Ettinger, you may proceed when you're ready.
May it please the court, Chief Justice, Justices, Counsel, I'm Richard Ettinger. I'm representing the defendant appellant Benito Fox. Mr. Fox is appealing his October 6th, 2025 criminal conviction. I would like to first focus on some important essential facts, which I believe are necessary and crucial to show that the trial judge abused her discretion in her order, i.e., she made an irrational, illogical decision in her thought process. Approximately 68 days before the trial in this case, Detective Sarah Cruz came to my office and picked up, this is important, picked up 3 devices from the accuser. The state admits that these 3 devices, an iPod, an iPad, and an iPhone, were all the accusers. And to accompany that on approximately, well, this was on April 16, 2025, docket number 41, which was the defendant's waiver of his right to a speedy trial, and the stipulation. I'd like to just read, I know I cited it in my brief, but I think it's important to see what the party stipulated to back on April 16, 2025. There was a stipulation to continue the trial, quote, because Mr. Ettinger provided evidence to Detective Sarah Cruz, it will take the Fargo Police Department several weeks to conduct its investigation, unquote. To accompany this, the defendant also signed a waiver of his right to a speedy trial. In there, he said, based on this investigation, I'm going to waive my right to a speedy trial. That's important because, in theory, the state is, as a justice seeker, is supposed to seek the truth and seek justice. To corroborate what I just said, besides the docket number 41 and docket number 42, this information is also corroborated in the police report, which, as luck would have it, is in the PSI addendum docket number 80. That starts on page 68, which is not numbered, but on the top of the PSI addendum, it says 52 of 66. So that's important information. Since the 66 days roughly before the trial, through the trial, and up until today, these 3 devices have been in the control, custody, and dominion of the state. Then, when I filed my Rule 412 motion, once there's no smoking gun at this time, our position hasn't changed, but as indicated in my offer of proof, I still don't have the smoking gun. But it's important to reiterate what I told the court on that. When I filed my 412 motion, approximately 15 days before the trial, quote, defendant moves the court for an order allowing defendant to present evidence that the accuser was involved in an inappropriate online relationship with an adult man. They exchanged sexually explicit messages and nude photographs with each other. Both the accuser's mother and defendant found out about the relationship. Subsequently, the accuser was disciplined and the relationship was terminated. This incident formed the basis and motivation for the accuser to fabricate these false allegations against defendant because she was in love with her online adult male friend, unquote. That's at docket number 50, paragraph 1, which I cited. Once again, based on the transcripts and my offer of proof, I don't have the smoking gun yet. As my brief indicated, and on docket number 106, the pretrial conference in camera portion, on pages 3 and 4, I give my offer of proof. And I tell the court that I got lucky, that I'm visiting my client at the jail. The jail staff was gracious enough to give him a computer, and lo and behold, on the Saturday before the trial, 3 days before trial, he gives me the flash drive, which I then, as indicated in my offer of proof, that's how I came to my offer of proof. And it's important to note that everything that we said and stipulated to back 66 days ago, everything we said that I said in my motion 14 days when I filed my motion, and up until my offer of proof, everything came together. It came to fruition. I blindly accepted what my client told me, and there, lo and behold, it was. Now, it's important to note that, as I cited on docket number 80, which had the PSI addendum, it talks in detail about the investigation, what they did and didn't find. It's important to note no place in that report does it say that anything about any illicit conversations that anybody had on that device. They never approached the accuser and asked her, is this true? Did you have this inappropriate relationship? Is this you, the person on here, that did these conversations? None of that occurred because it's not in the reports. So when the state claims that they make this bogus claim that there's foundation of law and authenticity, that's not true. These materials were found on the accuser's device. As indicated in that addendum, docket number 80, it was the last time these devices were logged on was 3 days before my client was charged. There was no evidence of any tampering. It's authentic. It's her devices. The defendant didn't have to prove beyond all doubt or reasonable doubt that this is authentic. He had the offer of proof included both the defendant, the mother of the accuser, and the fact that these devices are the accusers. That's sufficient evidence to go forward.
Mr. Ettinger, did the mother testify
Yes.
to that effect?
No, but it was in my offer of proof.
But in your offer of proof, shouldn't you have had her testify and instead of saying the mother will testify, shouldn't you have had her testify as the offer of proof?
I don't believe I need so as an offer to the court. I mean, she was subpoenaed, so we could have easily, since this literally happened less than a day before trial, we could have easily made that offer of proof if the court required it. But as an offer to the court, I mean, and like I said, everything that we said in our motion, our 412 motion, came to fruition. The fact that the state, I mean, in theory, the state is supposed to seek justice. If you want to know the truth, you ask the accuser, did you engage in this conversation? Whose illicit conversation is this? They don't even ask that. So then for them to argue in bad faith that this was, we're going to argue that even though this has been in our control and dominion for the last 60 days and there's no evidence of any tampering, we're going to somehow claim that it's not authentic or that lacks foundation. That's the antithesis of a justice seeker here. I mean,
Mr. Ettinger, when you refer to your offer of proof that was made in conjunction with the pretrial proceedings, is that correct?
yes, the day before the trial started.
Can you point, and I may have missed it, can you point me in the record to either the Rule 412 or the Rule 901 objections, were they renewed in the context of the trial during the testimony or reframed for the district court to make a determination? Because these were conditional decisions of the district court following the initial hearing, correct?
I would disagree with that characterization. Nothing changed based on our other objections, since she made her decision the day before trial.
So there's nothing in the record you can't point me to where you attempted to reintroduce the evidence and to have the court reconsider its evidentiary ruling?
There is a part, while I try to explain myself, not offhand, I can't answer that. Refer you to one at this time. I don't believe I have to, if you're asking, do I have to renew my objection during the trial?
I'm not asking if you have to, I'm asking, did you, right? Because there's a body of case law from this court that says we should grant the district court the benefit of being able to determine the admissibility of evidence in the context of trial. So a motion in limine is a preliminary proceeding that can be revisited later. I'm simply looking, did you renew it? Did you raise it again? Did you give the district court a chance to address the arguments that you're bringing to us?
I can't answer at this time. I will try to give you an answer I'll have to look at my computer with the transcripts during my 5 minutes of rebuttal.
Thank you.
Based on Justice Freese's question, based on the judge's ruling, the context of the trial, it wasn't a conditional ruling in the sense that, in my opinion, there was no opportunity to properly object or.
But paragraph 16 of the court's order says the court reserves the right to revisit this ruling based on the evidence and testimony introduced during the state's case in chief. Isn't that what Justice Freese is referring to?
Yes, but there was no, once I cross-examined I guess I'm going to withdraw. I'm respectful. I need to look at the transcript more closely before I answer that question. I guess as a argument, I would say is that issue wasn't raised. It isn't before this court properly. The state didn't argue that. That'd be my fallback position. But I will answer Justice Freese's question on my 5 minutes of rebuttal. But it's important to note once again here, the defendant waives his right to a speedy trial based on the, I guess, inherent promise that this is going to be a bona fide investigation. If the state wants to know the truth, they would at least ask the accuser, did you write these statements? Were you engaged in these text messages? Because what's important to the reason this is admissible is it doesn't go to the promiscuousness of the accuser per se. It goes to the fact that she's devoid of any type of principles or values, which if the jury has that, the jury is always left with, why would the accuser make this up? And as noted, that's why at the very end of the rebuttal argument that the state violates the 412 order and brings up the fact, well, why would she make this up? And I object, and then the state moved on. But
if I recall correctly, the court let you explore this was retaliatory. It just didn't let you get into the sexual conduct.
And they wouldn't. This judge wouldn't allow that. It was an inappropriate relationship.
Right, but that there was a retaliatory reason why she was making these accusations was not kept from the jury.
But there's a big difference. I would analogize that to Minnesota Vikings are playing the West Fargo Packers in a football game. We're not even in the same ballpark or league here, because a jury is going to left with the fact she was disciplined, because she spent 25 minutes too long on her Disney app or watching Disney, as opposed to the conversation with the adult male. And that's what our offer of proof was consistent from the beginning, is it shows the sophistication, an intelligent level, and somebody, makes an experienced criminal defense attorney blush with just how graphic these conversations are. And it goes to, it doesn't have anything to do with her sexual history. It goes to, she's devoid of principles and standards, which increases the chances. She's willing to not have any principles or standards or morals. She's willing to fabricate this, even though it's a AA felony. That's the important thing here. That's what the Kentucky case indicates, the U.S. Supreme Court case. That's what's important here. The defendant was deprived of his right to cross-examine, and if the defendant lost fair and square, nobody would have a problem with him being convicted. That's the risk of going to trial. But nobody wants to know the truth. Nobody asked the accuser, hey, were you engaged in this conversation? Even though the state represented they were going to conduct an investigation, shouldn't I have been allowed to cross-examine, at least ask her about this conversation? Then at least the jury knows she has a motivation to lie. That's the whole reason why on her rebuttal argument that the state intentionally violates Rule 412, because they know, put that in the jury's head, why would the accuser make it up when she knows what the basis is? It's been consistent for 66 days before the trial. That's why this court should reverse.
Mr. Ettinger, and I'm just trying to think your argument through, is there a reason that you couldn't have called the accuser at the motion in limine to testify, to help you lay the foundation for these things? Is there something precluding you from calling the accuser at the motion in limine?
I haven't really thought about that. I would say probably not, although I don't know. Once again, according to the case law, I don't have to prove beyond all doubt or reasonable doubt. Generally speaking, just like it's akin to a car, or if your phone, a person has control and dominion over their phone, over their iPad, and so there was no dispute that the smoking gun was on her device. So just common sense indicate more than likely it's her communication.
I am also aware that sometimes people within the same household might know each other's passwords, and parents might also have passwords for their children's devices. So that's why I'm wondering, it would not have been, do we presume because they are her devices when they're in a household where others may or may not know her password, that do we make those presumptions, I guess, is the question.
Well,
I know my husband's password to his phone.
That's fair enough, but the state, according to the last 50-some years, is supposed to be a justice seeker, administration of justice, seeking the truth. If that's the case, and you've promised you're going to conduct a bona fide investigation because the defendant is waiving his right to a speedy trial, and you're the only entity that realistically can investigate these type of materials, because what was found in the device was clearly a violation of federal and state law by the person who sent this to the alleged victim, that only law enforcement is going to be able to investigate that. So in theory, if you're going to conduct a bona fide investigation, in theory, that would mean that the state or the investigator would at least, at a minimum, ask the accuser, hey, we found these on your device. Ettinger's having this motion tomorrow. Anything you want to tell us about this? Did you create, or were you involved in this? But you can't, plausible denial, don't ask, don't tell. We don't have to tell Ettinger, we don't know the truth, but then we can argue because we don't know the truth, we're going to argue foundation, which once again, these were in the possession of the state. If the roles were reversed and this was a legal possession of illegal materials, a child pornography case, and the state needed evidence gleaned on those devices, you would get a very detailed, thorough abstract on all three devices, crystal clear, hundreds and hundreds and hundreds and thousands of pages, and we'd have no doubt everything that was on that device. But because this is going to help, because this, in theory, the truth should set you free. Why is the state hiding the truth? Don't they want to know the truth? That's the issue I have here is the defendant gave up an important right to a speedy trial. He was promised a good faith bona fide investigation by the state of North Dakota.
That's not your issue on appeal, though. It seems like you're arguing some type of misconduct by the state or those working for the state, but your issue on appeal is whether the district court abused its discretion.
And the district court relied on the state's argument, which I would say is bad faith, that we don't know because we don't have foundation. How can that be when they conducted the investigation? There is no evidence, not a scintilla of evidence there's any tampering. The stuff that we said that I blindly believed my client would be there was there. They don't ask anybody whose this is, and they pretend they have no idea when they do agree all three devices and the information was found on the accuser's device. So just logical deduction would presumably in most cases one can assume that it's the accuser communicated, but we don't just have that, we have the mother saying that, which would have corroborated that, and the defendant. That's based on the case law, that's clearly enough to show that there was proper foundation. This isn't just a guess, we know for a fact. And once again, only the state can investigate this. We respectfully submit they didn't, but as luck would have it, we still found the information. We made our proper offer of proof, and I respectfully submit the trial judge abused her discretion when she relied on the foundation and lack of authenticity when we clearly established there was. We don't have to prove beyond all doubt, but just you have to make your prima facie case, which I respectfully submit I did. And that's all I have unless anybody has any questions for me.
Hearing none, thank you, Mr. Ettinger.
Thank you.
Mr. Samuelson, when you're ready.
Thank you, Chief Justice McEvers, Justices, Mr. Ettinger, and may it please the court. This court should affirm the criminal judgment because the district court carefully balanced Mr. Fox's constitutional rights with Jane Doe's interests against embarrassment, sexual stereotyping, and the unnecessary infusion of sexual innuendo in the fact-finding process. Through this balancing, the district court correctly excluded evidence of Jane Doe's past sexual behavior because it was prohibited under Rule 412 and because the proposed evidence lacked the necessary foundation under Rule 901. The court did authorize Mr. Fox to pursue a vendetta defense, or that Jane Doe was motivated to fabricate these allegations because she was disciplined by Fox. So I want to start with...
Doesn't the nature of the discipline or the purpose for the discipline impact the vendetta argument?
To some extent, yes, and there's balancing that went on here. The state proposed during the motion in limine hearing that Mr. Fox could proceed with arguments about a boyfriend, something a little more neutral than getting into the specific sexual conduct which Rule 412 prohibits. I think those types of compromises made by the district court here do support a conclusion that this was not an abuse of discretion. So I want to begin with Rule 412 and its interplay with the right to confrontation. Rule 412 generally prohibits evidence of a victim's prior sexual behavior or predisposition, subject to 3 exceptions. The first 2 aren't in effect here. The third exception, of course, is exclusion would violate the defendant's constitutional rights. Mr. Fox is arguing his right to confront and cross-examine Jane Doe was violated here. In Michigan versus Lucas, the United States Supreme Court noted the constitutional right to confrontation is not without limitation, and it may, in appropriate cases, bow to other legitimate interests in the criminal trial process. So the constitutional inquiry, as I noted in my brief, is whether the district court's exclusion of evidence of Jane Doe's inappropriate online relationship with an unidentified male was arbitrary or disproportionate to the purposes that exclusion served. The explanatory note to Rule 412 states that it is designed to protect the privacy and against potential embarrassment to victims of sexual offenses. And this court, in promulgating the rule, based on the federal rule, has recognized those as important interests. I cited several other state court decisions in my brief where those courts also found similarly. Understanding that Jane Doe's rights against invasion of privacy, harassment, embarrassment, and sexual stereotyping are important protected interests, the question turns to whether those sufficiently outweigh Mr. Fox's right to confrontation. So here's where the district court got the balancing correct. It did not preclude Mr. Fox from developing the theory he wanted to develop, that Jane Doe fabricated these allegations because she was motivated by vengeance or a vendetta against Fox. Instead, it held that the sexually explicit reasons did not relate to that motive. He was free to argue that they were fabricated because she was mad about being disciplined. As I mentioned earlier, the state even proposed perhaps a neutral inquiry about a boyfriend and parental disapproval would be acceptable. The only limitation was as to sexual content, and that was a fair balance for the district court to strike here and was not an abuse of discretion.
Mr. Samuelson, is there anything in the record that discusses why it's Mr. Ettinger's allegation that the police investigating these 3 devices was less than than what they would usually do? Was there any police officer testimony about the depth of the investigation of these 3 devices?
I don't recall, Your Honor, and that wasn't necessarily an argument I was prepared for. I was prepared to address the abuse of discretion.
Part of it was I'm trying to, in my mind, distinguish devices of a victim versus devices of an alleged defendant. That when you're looking at a device to try to prove someone beyond a reasonable doubt of some crime that was committed on that device, or there's evidence on that device, it might be different than that from a potential victim.
And I'm not sure, Your Honor.
If it's not in the record, that's okay. I was just curious if some of that came out in the motion hearing.
Thank you, Your Honor. Somewhat intertwined with the 412 issue is the issue of whether there was sufficient evidentiary foundation for this proposed evidence. In his reply brief, Fox doubles down on the claim that the state was being disingenuous when it objected on authenticity grounds. But the state would submit that Mr. Fox is misreading what we argued below and what we're arguing here on appeal. We're not claiming an issue with chain of custody. We're not claiming that Mr. Fox or his counsel tampered with these devices before turning them over to the police. And we're not disputing that the devices belong to or came from Jane Doe. We are raising legitimate concerns that the district court also found legitimate. Specifically, there was no context about the text messages between Jane Doe and her mother about not going to certain websites. There was no foundation regarding the Snapchat exchange and photograph. So how do we know that they were related? Oh, excuse me, skipped a line there. We don't know who took the picture, who received the picture, when it was received, on which device it was found, and who the person is depicted. And then it's also unknown who the parties to the Discord messages were or on which devices they were found. So it's...
Mr. Samuelson, is there some validity to the defense argument? Of course, the defendant can no longer do a deposition of a victim. It has to be raised in this context, and Mr. Ettinger makes much of the offer of proof that he made regarding the foundation and admissibility of this particular evidence. How do you respond to that? Is the offer of proof enough, I guess?
As to the...
Both foundation and admissibility.
As to the foundation, I don't believe so. I don't think there was any information presented kind of connecting the dots here between what was proffered and the claims that were to be made. I think the district court...
And I'm sorry for interrupting. So then my question is the same that I had for Mr. Ettinger. Is there something on the record within the trial transcript that I missed that shows that those foundational defects were attempted to be cured in the context of trial or in the context of the testimony?
I can't recall if it was raised again at trial. I tried to take a quick look at it, but I wasn't able to find anything in my notes, so I don't know the answer to that. I apologize. So without the proper foundation, it's impossible to connect the dots.
Let me interrupt. What about the argument that this information is in the state's control at this point, and they're the ones that could have laid the foundation but declined to do, according to Mr. Fox, any meaningful investigation?
I wasn't involved at the trial court level, so my understanding of all of this is from my review of the record. I don't recall that argument coming up below. If it did, I missed it. This evidence was brought to police by Mr. Fox, so certainly important, and I don't know the exact scope of their investigation. I can't recall if that was borne out in the record at all. In any event, the district court held that Mr. Fox was not precluded from arguing that the victim had a vendetta against him. It only barred him from presenting the past sexual experiences as prescribed by Rule 412. Because the district court, in its sound exercise of discretion, carefully balanced Mr. Fox's interests with those of Jane Doe and found an overriding interest in protecting Jane Doe's privacy, it did not abuse its discretion in its application of Rule 412, and the state respectfully asks that this court affirm the criminal judgment. Thank you.
Mr. Samuelson? Mr. Ettinger, it looks like you have 5 minutes reserved for rebuttal.
To answer Justice Freese's question, on page 91 of the transcript, the July 23rd, 2025, I believe it'd be docket number give you that cite in just a second, Justice Freeze. It says, Mr. Ettinger, Your Honor, quote, based on your 412 order, I wasn't going to get into that, but you did indicate on the record that discipline, it would be appropriate cross. I was going to just ask, and then so I asked the court's permission for discipline, and then there's a little discussion. The Assistant State's Attorney talks about it, and then on page 92, I indicate I'm not going to violate the court's order, and then the judge indicates what appropriate line of questioning is. I would respectfully submit that colloquy would be enough for purposes of protecting for appeal. I would note that you're correct, Justice, where I deemed, based on the record and the fact that there was no dispute that these devices came from the accuser, and based on the fact that I had both the mother, who was subpoenaed, and my client, we're going to verify that was enough for my offer of proof, and I respectfully stand by that. But I would note, as indicated on that addendum, PSI addendum number 80, it has the whole police report about this investigation, and nowhere in there, once again, if they would have asked the accuser, it'd be in the report. So by deduction, the fact that it's not in there is relevant information. But once again, as the Chief Justice indicated, the issue is, did the trial court abuse its discretion? I understand that's a high standard, but when you have an illogical thought process like we do here, that there's a lack of foundation, that's just simply not true. The defendant gave plenty of information, and once again, when he's 66 days before he knows what the truth is, we ask for this investigation. 14 days, or roughly about 10, 11 days before we get this smoking gun, we file our motion and say what our basis is, and then lo and behold, based on data I received from my client at the jail via flash drive, I got lucky, because my client is a data scientist and somebody at the jail afforded him a computer. But for that, we wouldn't have this issue, because I would have known about any of this material. That's important to know. That in theory, the state is supposed to be a justice seeker. Hiding the truth and not asking what the truth is, that's not justice. That's usurping justice. I'm not engaging in hyperbole, but that's what happened here.
Again, that sounds like a misconduct argument. What's the district court judge supposed to do?
The district court judge is supposed to make their decision on the evidence. And the evidence in the file was that the state and the defendant agreed to continue the trial, and the defendant waived his right to a speedy trial because the state was going to conduct an investigation. And when you conduct an investigation, in theory, an average investigator would at least ask the person who owns these devices, hey, what about these messages that Ettinger is raising tomorrow in his 412 motion? Do you know anything about this? Do you want to comment on that? But I don't believe the state can argue, don't ask, don't tell. We don't want to know the truth, but now we can at least argue we can argue now, hey, we're going to argue foundation and we think this is bogus, even though these unequivocally were found on the accuser's device.
Thank you for your arguments this afternoon, Mr. Ettinger, and Mr. Samuelson for yours as well. This case will be taken under advisement, as all cases are, and court is adjourned until 2:45 p.m.
All rise.